Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us my partner, Hunter Lewis.
Good morning.
Welcome,
Good morning.
Hunter.
How are you?
I'm so glad you're here.
Excited to be here.
We're going to talk about litigation.
We are one of my favorite things.
You are definitely a good litigator.
Well, I appreciate that.
And I'll tell you why I think you're good is you are technically strong, which, you know, when people see court on TV, they kind of think, oh, don't I just get to go tell my story, which we know is not exactly.
Oh, it's not. And it's actually frustrating in our practice. The number of people who come in and say, well, I've seen this. Can we do this? And I love people, you know, really helping with their cases. But man, TV is very different than what we do.
Yes. And when I say you're technically strong, what I mean is you know the rules, you utilize the rules.
Man.
Not all lawyers do that. But you're kind of on the nerdy side in that way. But you're also a very strong oral advocate, meaning you are a gifted speaker. And in my experience, those don't always go hand in hand. So I think you have superpower.
Very true. Well, and it's funny you say that because I do. I even remember in law school, there was a push of, are you going to be one of those that is technical writing, technical research, or are you really going to focus on the oral skills? Are you going to focus on, you know, the oral argument, on the presentation itself? And you're right. You don't see a lot of people who really know how to not only do both effectively, but also use both in the courtroom.
Yes, and you're so good at that.
Well, I appreciate that.
You can call it, and everything moves so fast in court, right?
It does. It does.
You have to be able to not only do it, but pull it fast to your brain and be like spotting, getting, changing course.
Exactly. A lot of recall, too. A lot of things, right? The law changes so frequently. And so there's so much recall we have up there that's just, oh, well, this just happened, you know, and that's what I think makes an effective oral advocate is somebody who, you know, stays on top of the game and really stays on top of where the law has gone and how we can present that effectively and efficiently to a judge, right? You know, how many courts do we have now that are really enforcing kind of strict time limits?
Oh,
right?
My gosh.
Just
Got
miserable.
rough. So we have to get to the point. You don't have time to mill around the point.
Right. Have to be succinct. Most courts now are giving you about 20 minutes aside for hearings. You know, we have several courts that are giving you less than that, right? And even at final trial, we have several that are giving you significantly less than that. So, you know, in order to find an attorney that really helps your case, and what I think that our firm has really been strong with is being able to present a very succinct case powerfully in a very limited amount of time. And that takes practice, that takes experience, that takes all sorts of things that I think are really something people should look for in a good attorney.
Yeah. Preparation.
Hands
There's
down.
some things you can do pre-suit to save yourself time at trial.
Oh,
right?
Absolutely.
Not everybody takes advantage of that.
We try to help them, right? But
Yeah.
they don't. You know, there are things an attorney can do before trial. There are things an attorney can do before hearing. But there are also things that you as a client can do to help your own case, right?
Yes.
And we try to really develop that because I think what's lost in a lot of attorney-client relationships is that it is a relationship. You know, I think we lose track of the fact that we are working with somebody for a collective goal. We're not looking at just being their, you know, mouthpiece, right?
No one knows their case better than the client.
Exactly.
And I think sometimes we are just natural know-it-alls as lawyers. And sometimes we think we know it all. I've had cases where the client told me something and maybe the first time I kind of didn't register, I didn't fully understand, or I disregarded it. And then they came back with it. And after 2 or 3 times, I thought, I need to listen to this better.
Oh, absolutely. And it helps. It does. It helps a lawyer. You know, when I'm meeting with a client, it helps when I say things like, you know, it's okay to be candid. It's also okay for you to speak freely, to tell me how you feel. You know, there absolutely is this air a lot of times of people that come in and are very cautious with how they approach a litigator specifically because they want to make a good impression. And I always remind people, I don't need a good impression. I need
a
to know,
real impression.
Right. I need to know how you are going to present. I need to know how a judge is going to see you. And then we can figure out ways to work with you to not only make your story more succinct and more efficient for a court, but also help you prepare more specifically for that. And I think, to that point, you know, not everyone's good at testifying, right? Just like not everyone is good at litigating in court. Not everyone is good at testifying.
Right. Oh, it's so nerve-wracking for clients. They're nervous, of course. They're not practiced at it.
Right.
And I do think that my observation, I've done this a long time now, is a lot of lawyers, not at my firm, but other firms, are not preparing the client enough.
Absolutely.
You have to practice with your client. They have to be comfortable. They will blurt out something that isn't even accurate that hurts their case because they're nervous.
Absolutely. And I do think, and we've discussed this, you and I have actually discussed this too, there's a difference between having scripted responses and a prepared response, right?
Mm-hmm.
We look for ways to make the client look genuine, ways to help the client truthfully tell their story, again, in an efficient and meaningful way. Right? But there are things they can do that ultimately will impact how they testify, and there are tricks of the trade that we present. And I think that's why it's important that you have somebody that really has had that litigation experience,
Mm-hmm.
and that's something that I think we absolutely offer, top to bottom at our firm, is we have wonderful lawyers that have loads of experience, but also that have real world practical experience, right?
Mm-hmm.
It's not just saying this is what I think is going to happen in court. It's I have been in front of this judge, and these are the types of things that work.
Mm-hmm.
And I think that's what makes an effective advocate is, like you said, not only preparation, but also that experience,
Mm-hmm.
that tried and true experience that shows, we have had success in these courts and we know how to make this at least as successful as possible. Now, obviously, like you said, we also can't change the facts, right?
Oh, the facts are what they are. If I could possess my client's body for about 2 months and go live their life better, I would.
Right.
But it does not work that way.
Oh, it's not. And we take what we get and we work with what we get. And a lot of times I can tell you the number one thing I hear really is, oh, you've probably never heard something like this before.
Or
oh,
like,
right. Or, oh, this is really traumatic and this is painful and I'm sure the court's never heard this. No, there's
they heard
really,
it yesterday.
right. There's really no nuance. They'll probably hear it 5 times before you get there, right?
Yes.
There's really no nuance. So, I tell people, don't take ownership in the fact that your facts are any different than anything they've heard. Just take ownership in the truth. Right.
Yes.
And that's really what makes it more effective, because just like they could come in and try to put on a story for us as their lawyers, if they do that in court, judges see through that. Right. And the best way to litigate and the most effective strategies involve truthful storytelling, involve honesty. People make mistakes. Lawyers make mistakes. Right. And at the end of the day, judges want to see that. Judges don't expect you to be perfect.
Mm-hmm.
And I think that's what really helps in terms of litigation strategies, right? Is helping people understand that at the end of the day, we're just all real people going through real problems. And we deal with those problems every day, especially on the family law side of things.
Judges will forgive most anything if you take personal responsibility and you're taking steps to fix it.
Absolutely.
So, for example, when it's a custody case,
right,
and somebody is saying, well, I don't want to go say that I'm on antidepressant medication because they'll think I'm crazy. I'm like, no, the judge will like that. You recognized you needed help. You got help. You got appropriate medication and you're taking it.
Sure.
That's plus, 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 plus.
Right.
Not minus. They're very educated on the whole, our judiciary, about mental health.
Absolutely.
They recognize people need help. What they don't want is someone who needs help, is not seeking it, is not taking any medication, and it's impacting the child.
Absolutely. Absolutely. Well, and I can tell you, to that note, I have a case very similar that's kind of a historic case for me. And for years, the judge has specifically said, and so what did you do to contribute to this? Judges ask questions. And in this specific case, the judge has consistently said, and, do you take responsibility? What have you done to contribute to these issues, right? And until that client understands what that client has done and is able to accept it, the judge recognizes that. And the judge is going to, again, take slow steps to get to where we want to be until that client recognizes it.
Yes.
And, I think that really does come down to why truly having someone, especially on the family law side of things, understand litigation. It's interesting because there are a lot of different ways by which you can resolve a case in family law. And people specialize in all of them, right? And I think it's great to have somebody who is well-rounded in all of those, but specifically if your case looks like it's going to court, to really have somebody who has that background of stylistic presentation that they are familiar with. I can't tell you, my mother, who obviously was a former sitting judge and one of our partners, I discuss with her frequently how amazed I am when I go to court and I have lawyers of significant name and stature come to court and they just don't seem prepared.
Oh, I know. That is my pet peeve. Same for mediation. As a mediator, it's amazing how many people come ill-prepared. I do not understand it. I mean, I'm preparing a seminar right now on mediation prep. I'm going to do it in our firm first. I mean, I just do not understand why it's such an expensive day, whether it's trial or mediation.
Right.
Why would you not spend the time to be prepared and have the best result you can?
Absolutely. And I think, too, to the preparation point, again, we lose track of the fact that it's not only preparation for the client, it's also preparation for the lawyer. And, sometimes there is that lost communication of we are spending so much time trying to have our client present well and trying to have our client be the one that really expresses a lot, when in fact, the client actually has to help us as the litigator, tell us how to effectively cross-examine somebody, tell us how to effectively present parts of the case that maybe we aren't familiar with. And that's because, like you said, they are the ones who know their story best. And a good litigator can then take those facts and present them effectively, but also use their experience, use their knowledge of the law, and specifically the most recent law to really make that an effective argument. And that's something I'm seeing too, and I think we've also discussed that, is that a lot of times when I'm in court now, especially over the COVID times, as we like to call it, right? We've seen a significant amount of changes, not only in how we practice, but also in the law.
Yeah.
And being effective as a litigator, you really have to be familiar with those, whether it be this nuanced and novel idea of Zoom hearings, right, that we started in 2020. And now I think a lot of people have really figured those out to some extent, right? Two, truly presenting new evidence under our new statutes. We just finished a legislative session, and there were some significant changes.
Yes.
And so understanding, being able to tell the judge and represent the judge, this is the legislative meaning, this is where we are going, this is how the law changes, and this is how it's going to strengthen our case. And so a lot of times the number of times I actually was looking at this yesterday in a case I was dealing with, the number of times I even still read pleadings that are 2, 3, 4 years old in terms of their form and under correct law. I still see lawyers file things that are under old statutes.
Right. Oh, let's talk about pleadings, because this is an area where I think you're very technically strong.
Well, thank you.
Is paying attention to the pleadings. And you can sometimes eliminate a case, eliminate something somebody can bring up at trial or in a hearing because they did not plead for it.
Oh, absolutely. And the number of times I hear, the first thing people say is, oh, it's in my pleadings. Well, the number of times that has been incorrect is astounding.
I agree.
The number of people who don't start with their pleadings when they are preparing for a hearing. We train a lot of young lawyers as well in our firm. And the number one thing I say to them is always start with the code and your pleadings. You need to make sure your pleadings align with what the statutes allow and that you have pled for everything you want to put on. And the number of people who don't do that.
I know. And they wait too long. Like, this is a reason for preparing ahead.
Right.
You need time to replead. You're allowed to replead. But maybe at the beginning of your case, you hadn't developed it yet.
Right.
You didn't know all the things you needed to plead. That's normal.
Oh, it's very normal.
And they allow you to replead, usually 7 days before trial, although that could cause a delay because of surprise. But it's still allowed.
Absolutely. And most of our hearings even say, just for a general hearing, right, is a 3-day reasonable notice. And so you will see people pleading outside of 3 days to get something set really quickly, which again is standard. But that also goes to the fact that people don't know what they have pled for. I was in an argument in a small county about a week and a half ago now, and I remember opposing counsel stood up and made this grandiose argument and then said, well, and Mr. Lewis has pled for this. And I said, Judge, respectfully, I haven't pled for that. I'm happy to fall on my sword if that is something that I have pled for, but I don't think we can open the door into that line of questioning because it's not in my pleadings. And sure enough, they flipped through and said, oh, we were looking at the wrong thing, or we were, So again, it's just understanding that what you have before the court is what you can move forward on. But also, again, that preparation aspect, right? But then to that element, we were talking about this earlier, there's also an element of making sure that what you have pled for is also specific enough for purposes of appeal.
Yes. Right? In case it's going to be appealed. Hopefully we win and they don't appeal.
Yes, hopefully we win. But the interesting thing, and one of the nuances in family law that we have that a lot of other areas of practice don't, is that in a lot of our major counties, we have these really novel courts that are associate courts, that are statutory courts that then feed into district courts. And the district courts are allowed to give their associate judges power over certain types of hearings. And so if you have a hearing that is usually starting in an associate court, that's usually like the first line of hearings, if things don't necessarily go your way, you are entitled essentially to an automatic appeal.
It's a do-over.
It's a do-over, right?
That's so rare in the law.
Right. And you don't necessarily want to plan for that, but sometimes there are things, and I use this example quite frequent, protective orders.
Yes.
Protective orders are subject to family violence findings. Those are serious cases involving family violence, involving abuse, kind of the hard stuff of what we do.
Mm-hmm.
And a lot of the courts now send those cases first to their associate judges. And because they are involving violence, they are expedited. You don't get discovery. You don't get a lot of time to prepare. They're usually set within 10 days of being filed. And so you don't really have a lot to go off of.
Mm-hmm.
But the good thing is that if you plan it right, and if you do have a rough day in court, you already have prepared for what they are presenting, and you get that automatic do-over, right?
Mm-hmm.
And so you really can use that as a litigant to your advantage. And obviously, again, there is still a high level of preparation, but it's just understanding the nuance of how what has been said can be used against you at a later hearing, making sure you're perfecting your record and making sure that things are appropriate for purposes of then taking that second step and maybe bringing it back to a district court that'll hear it again.
Yes, so don't underestimate how you're pleading and knowing your pleadings and knowing what they pled, because you could not think it's going to be an issue, and then in the middle of the trial or the hearing, something happens and you're like, whoa, I don't think they pled for that.
Absolutely.
Okay, let's move on. Evidence.
So
the reason that it's not like you just get to go tell the judge everything is there's rules of evidence.
Very strict rules, yes.
And they're not clear cut always.
No, they're not. There's a lot of gray area in evidence. And honestly, that's also part of why I always say it's important to have someone in litigation that understands the county in which you're in. The rules of evidence are fairly specific in the Texas rules of evidence, right? But county by county, will issue either local rules or standing orders that change those, right? Some will issue orders that have standard injunctive relief that's not necessarily statutory across all courts. By way of example, one that I do find really interesting that is keeping up with the time, and I have to remember, so being in practice now 15 years, I remember starting in practice when we were using fax machines. And we were using, old forms of communication. But
the family code was much thinner.
Right. And what's funny is the family code doesn't really catch up with that stuff really quickly, right? Those are kind of slow processes. But it's interesting because some counties have really taken it on themselves to really advance the practice. And evidentiary speaking, Denton County, a great example. They have new forms that require that when you file a suit, you also have to file an acknowledgement that you're not using AI and technology, right? You're not seeing that across the board, but it's interesting because, again, knowing the county you're in, practicing there, and having someone who is litigation savvy in that county is really important.
Yeah.
Because you have to understand the nuance of that evidence, because there are exclusionary rules, meaning there are courts that have said, if you do not meet my court-specific rule, we'll keep your evidence out. And that could be detrimental to your case.
Yes. So the point of the rules of evidence are to try to get the most reliable evidence in front of the judge and lessen the chance that it's false or not reliable or appears to be something that it isn't.
Correct.
And that's the goal, right? Is how do we get the most reliable evidence? So there's two sides of evidence. One, what we're trying to get in,
Right.
and what we're trying to keep out.
Correct.
That the other side might have. So, knowing how to object to it and being able live when it's all happening to be able to pull from those rules, that's important.
That is important. And like you said, you keep saying it's thinking fast on your feet. And that is absolutely a talent and a skill that some lawyers really possess. And you can tell that some don't. We are on time limits, like we said earlier. And with that, you have to be ready to state your objection, state a legal objection. I get in trouble a lot of times because I'll state a couple of legal objections and then I'll throw in some speaking objections, as we call them, which are me explaining why this evidence shouldn't come in. But it's really important to be able to pull from a really significant tool chest of those objections, because evidence is how your case is made or broken, right?
Mm-hmm.
And with that, it's important to have a lawyer who understands, again, the nuance of not only the objections, but also the nuance of how to get their own evidence in to that second point, right? And that goes back to the preparation, because the number of times we have clients that come in and say, oh, I have this great evidence, and then they hand you this piece of paper. And that piece of paper is probably something that they may or may not have received in a, let's just say, sorted fashion. I don't know, right?
Illegal.
So, I'm not going to go so far as to say illegal, but maybe disallowed, questionable, something of that nature, right?
Maybe violated a privacy rule.
Right.
Maybe.
Right, maybe. And I don't want to assume that they do that.
You have to ask a lot of questions.
Right. But we get that regularly when they come in and say, well, here's this communication. Okay. How are you a party to that communication, right?
Yeah.
And so it's important, again, as a lawyer, to not only stay up to date with how evidence like that is admissible, and that is a lot of moving targets, truthfully. A lot of the case law we're seeing right now is specific to electronic communications, electronically stored communication, artificial intelligence. We're seeing a lot of that being the new nuance of, admissibility standards, right? And so it really is important that you find somebody who can know that and who has stayed up to date with that, because we don't know the best evidence. Mm-hmm. And if the best evidence is, a WhatsApp or some kind of, technologically advanced form of communication that maybe the courts haven't seen, we have tons of different apps now and tons of different communication platforms. And because of that, courts really are hit with new evidence almost every day, I would suspect. Mm-hmm. They see new things. And because of that, I think you really need to stay on your game as a litigator. And that's something that is important. And, we try to keep that in our practice. Obviously, we do internal continuing education on things like that. And we try to train our lawyers. But across the board, you can't really see that in practice.
Mm-hmm. Okay. Another thing that I have seen you and your mother utilize that I think is underutilized is motion for directed verdict.
Yes, absolutely.
Explain how that works.
Well, it depends on if you have a jury or not. But a motion for either a directed verdict or a directed judgment, right, is basically saying the other side has not met their burden. When you are presenting a case, there is what's called a burden of proof, which we're aware of, which means that the party presenting has to present a sufficient amount of evidence to support the claims they are making. In layman's terms, you got to put on evidence to support what you're asking the court to do.
And this is before we've even put on our side of the case.
Correct.
They put on their side of the case, and then before we even start.
Right. Absolutely. They put on their side of the case and say they're asking for a change in primary. Actually, I'll do one much more easy. I had a case out of another county that was seeking to give grandparents access.
Okay.
And the grandparents' access standard is very high.
It's getting higher every
every
time the legislature meets.
And part of this case involved terminating, because the way grandparents were going to get access is we had to terminate the other side. And with that, termination has multiple ways by which you can terminate a parent-child relationship. And after the movant, who has the burden of showing why they should get the child, presents their case, we presented evidence, and I stood up and made an objection and said, Judge, respectfully, they haven't met their burden on these 3 grounds, which are in their pleading. So before we even start our side of the case, you should go ahead and rule on that and say there isn't sufficient evidence to support it. And so we don't have to put that part of our case on.
Right.
And it really does. It's very underutilized because a court can limit what we even have to respond to. It is a time-saving method. It absolutely is a litigation strategy that helps us because then we can shift our focus to things that we think are more critical than maybe ancillary issues that were just pled for and we can get rid of very quickly. And a lot of times people really forget to do that.
Yeah.
They do. They absolutely do. Or they don't know how to do it appropriately. That's the other issue. And that, again, that scenario changes if you have a jury. Obviously, there is a different scenario where you ask the jury to be excused, But again, that's why you need a litigator who understands that nuance. Because if you have somebody who is quick on their feet, you can save a whole lot of time, and what I know people love to hear, a whole lot of money. Absolutely. If you have somebody who really understands that.
You talked about getting ready for appeal when it's from an associate judge to a district judge,
Yes,
which that's all within the same case.
Right.
But we also need to do certain things at trial in anticipation of an appeal to the Court of Appeals after the whole district court case is done. And not all trial lawyers think that way. Of how do I preserve my record?
Absolutely. And that's a great point. The funny thing is that a lot of times people forget that you have to preserve your record even if you don't intend to appeal. Say I am having a great day in court, and we know we're having a good day in court. The judge is giving us a lot of those intermittent rulings that are really beneficial. We see we're going in the right direction, and we know we're going to have a fine ruling at the end. It is still important that we not only hold the other side to appropriate evidentiary standards, but also that we perfect our record and do the same thing, because the other side also has the opportunity to appeal when the case is over, right? And we want to make sure that we have presented enough evidence sufficiently and prepared a record that the Court of Appeals can say, well, the judge, within these discretionary issues, can absolutely rule in my favor. And so the appeal is bunk, and we don't need to move forward with it. So you really have to make sure that you're always thinking 2 steps ahead that way. And again, there are a lot of times where I see people, and specifically litigators, just not prepare. They don't offer evidence correctly. When evidence is excluded, they don't make the appropriate offers of proof or appellate record procedures that will preserve their record in the future.
And part of that is time,
It is.
right? So if we're time limited, sometimes the trial lawyer has to make a judgment call. Do I have time to make that offer of proof?
Right.
Because you're kind of telling the judge what they would have heard had they allowed it. But sometimes you're making a time. Sometimes you're irritating the judge. Right? So you have to make a decision of how likely is this case to be appealed by someone, and am I okay, irritating the judge? Too bad, judge. I have to make my record,
Well, and part of that too, like you said, is the fact that we have to make appropriate objections. And I know it seems kind of, minuscule in the big scheme of things, but if you don't make an objection, you've waived it on appeal in a lot of cases. And so you have to make sure that if something is being presented and you don't love it, if you have objected and the judge lets it in anyway, you really should re-urge the objection and or make every objection you can to that if you think it is going to be something that's going to damn your case. Because ultimately, again, you want to have preserved your record and that objection for appeal and not have waived it at the time of trial.
And the judge doesn't want to be overturned on appeal.
No, absolutely not. Well,
you would think they would understand I'm just trying to make my record, but sometimes they're irritated and they tell you to move on.
Absolutely.
And you have to be strong enough to say, Judge, sorry, I have to make my record.
Right. Well, and the great thing is that, yes, you have to have the nerves to do that. But also there have been times when I have done that and said, Judge, respectfully, I need to make my record on this. And you start making your record and the judge does reconsider. And the judge says, you know what? Actually, after hearing this, you're right. I'm going to reverse myself because of this. And I've seen judges self-reverse. I mean, I will say the good thing is that most of the judges we appear in front of are very self-aware.
Yes.
I mean, they really are. They're aware of the fact that there is gray area, but they're also very aware of the fact that they are bound by the law and they have to follow it,
And you might be appealing.
Right, right. So again, that's why it's important that you have somebody that has that knowledge, not only of the litigation side, but also of the appellate side as well.
Hunter, what all areas of town do you work in and cover?
Yes, mostly North Texas. So we try to, and I say we, my mother and I try to keep our practice kind of isolated, but a lot of cases in Collin County, Denton County, Tarrant County, and then we have some in Rockwall, some in Ellis County. We really are all over. I've had some in Travis. I've had some in Harris. I've had some in Johnson. We're all over where we need to be, but we tend to focus more regionally on North Texas.
We're going to put your contact information on the screen.
Great.
Thank you so much for being here. I think this was a great quick view of, hey, litigation's more complicated than it might look like.
Oh, absolutely. Absolutely. Well, thank you for having me. Always a pleasure to be here.
You're welcome. Thank you for tuning in to the Melinda Eitzen Show. Please tune in again.